Done it sometimes. I don't like it. I've done it, but when I've done it, it's exactly this, where somebody's just accumulating so many felonies, there's nothing left to do. So you're in an environment now where even possessing drugs, given your lengthy history, as a judge, hang on, you don't want to do that. As a judge thinking about whether prison's appropriate. All those things that they both said are all true, right? Because people are a mix of good and bad, and it's rare that you encounter somebody that's all good or all bad. And you've already, I don't need to tell you what drugs is going to take away from you. You've lost kids. You've lost, I don't know if you've had much employment. You don't have much education. You've had some crummy things happen to you. You've done some crummy things. You've got some mental health struggles as well. Drugs have contributed to all those things. So drugs is just robbing you of every single good thing that's available in this world. So all the stuff that happened to you in the past, you can still have some good things in this world, but not with drugs. You already walked that path long enough that there's nothing there but darkness for you. The prosecutor's right. You got a bunch of prior felonies. You're absconding in this case. You got guidelines in both of these that would let me send you to prison. Discretionary consecutive. But you know what I didn't hear, what I don't see when I look at this history is deliveries. They're all possessions. Not just that they were pled to possessions, they're all charged as possessions. So, you know, it's tough to find judges, and it should be hard to find judges who are real excited about sending people to prison for possession. I've done it sometimes. I don't like it. I've done it, but when I've done it, it's exactly this, where somebody's just accumulating so many felonies, there's nothing left to do. So you're in an environment now where even possessing drugs, given your lengthy history, as a judge, hang on, you don't want to do that. As a judge thinking about whether prison's appropriate. I've done it sometimes. I don't like it. I've done it, but when I've done it, it's exactly this, where somebody's just accumulating so many felonies, there's nothing left to do. So you're in an environment now where even possessing drugs, given your lengthy history, as a judge, hang on, you don't want to do that. As a judge thinking about whether prison's appropriate. I'm not sending you to prison today. I just want you to know you're in the ballpark now where you're close to going to prison for just possession. In this case, I've got a 2021 traffic stop. Miss Williams is a passenger. She's got a personal use amount of heroin with her. It's charged in 2025. She's arrested in 2025 on it. Then she fails to appear and gets an absconding charge as well. There's no indication of more criminal charges or convictions after the date that she absconded. So I think there's no aggravating factors for that absconding that would cause me to think about consecutive sentencing. So in the exercise of my discretion, I'm going to do concurrent sentencing and not stack the cases. Mr. Gilbert gave some good reasons why time served would make sense, and I even wrote some notes to myself that there's some reasons why that might make sense to allow you to begin the New Paths program in probation in Genesee. You know, the prosecutor made a pretty good, reasonable pitch for why you should go to prison, and I'm not doing that. Where the guidelines, especially in the absconding, are 10 to 28 months, it's kind of hard to justify, a downward departure. Or shoot, even lower end is tough to justify given your history. So I think the recommendations from the Department of Corrections, I think, are pretty measured and pretty proportionate. So I'm going to adopt those. And in both these files, order that you serve 12 months in the Sheboygan County Jail, give you credit for 236 days served in 7111, 233 days served in 7112. And those will run concurrent with each other. In 7111, there's state cost of $68, crime victims assessment of $130, and court costs of $350. in 7112, there's state cost of 68 and a crime victims assessment of 130. I will indicate, I mean, you've already got credit for a bunch, so I don't know whether you'd be eligible for these other programs, but to the extent you've got more time to do in Sheboygan County Jail and would qualify, I'll put on these judgments. I have no objection to Ms. Williams participating in either CBT programming or trustee program with credit if the jail determines her to be eligible for those. And Ms. Williams, if you wanted to file an appeal in either or both of these cases, you'd have to file an application. If you wanted a lawyer, you'd have to ask me within 6 months. So we're going to hand you some piece of paper about your appeal rights. We're going to ask you to initial 1 copy in each file, so we have a record we gave it to you. The other one's for you to fill out if you want to take an appeal. So bottom line, it's 1 year. You're sitting on what, about 9 months credit? Almost, not quite, about 8 months credit. So you got a couple more to do if you get good time, and then you go off to Genesee, and good luck. Good luck to you on probation. Okay. I have somebody zooming in on a fire tablet, which might be Miss Young.
I thought she was going to be here when I talked to her today, but
You're still, you're muted there. There you go. What's your name?
Joni.
Okay, this is file 25-7086. Ms. Young is appearing by Zoom video. We've got her lawyer, Mr. Gilbert, here, and the prosecutor, Ms. Goodrich. And this SORA case, we had adjourned it to see if she could come into compliance. Do we know where she's at on that?
I guess I'm looking for an update. My understanding was that she was heading there and she should be in compliance as we speak, but I guess I'm gonna have to turn it over to my client to update us.
I had went and they were unable for me to verify outside of my vacation months, but he did update all info and advised me of my needs to verify, and he made a payment to the county clerk on my fines.
I'm not sure what all that means with that. You Ms. Goodrich, in any event, you want to confirm compliance anyway. So we should continue this to the July 7th docket. Allow you to do that.
Please.
Okay, any objection, Mr.
None at all.
Okay, so we're going to continue this docket call to July 7th at 2:50 in the afternoon. Allow Zoom appearances, and that'll give the prosecutor time to confirm compliance. My understanding, based on previous discussions in this file, is if there is compliance, that might resolve the matter. Is that right, Ms. Goodrich?
Yes.
Okay. All right, so if that happens and you just want to submit a nollie before then, I would sign it. All right, Ms. Young, you're all set today, okay?
All right, thank you.
Good afternoon. We're on the record in the 53rd Circuit Court for the County of Sheboygan, and we are providing public access both in the courtroom and also online. And we'll start our afternoon docket with People versus Michael Delaney. It's file 25-7080FH. Counsel, you want to state your appearances beginning with People?
Melissa Gersh, what kind of costume?
Brian Clinton, on behalf of Michael Delaney. He's on Zoom, as am I.
All right, good afternoon. And this is time and date set for a docket call plea cutoff because we are scheduled for a jury trial in late July. So what's our plan, Mr. Clayton?
It looks like we're having a trial. I'm showing dates of July 27th and 28th, Your Honor.
Okay, fantastic. And witness and exhibit lists already been exchanged then?
Yes, sir.
I just submitted mine. If Mr. Playhood could send up his in 7 days, that'd be great.
Okay, I'll give you both 7 days to file or amend any of those. And no need for any additional hearing. Mr. Clayton, we'll see you on the 27th then?
Yes, sir. Thank you.
All right, let us know if anything changes. Otherwise, we'll see you next, Mr. Delaney. Obviously, that next appearance, Mr. Delaney, will be in person with you and your lawyer for the jury selection, and we'll go right into the trial that day and into the next as needed. All right, have a good afternoon.
Thanks, sir. You as well.
Yep. Thank you, Your Honor.
All right.
Somebody kick me out.
All right, and Mr. Kukuski, you can call People v. Marshall Harley.
That's going to be after Mr. Harley.
And this is files 26-7141 and 7146. We're here for docket call, and in 7146, some bond issues. And what's our status here, Mr. Kukuski?
At this time, Your Honor, Mr. Harley, well, I guess us and the prosecution have come to an agreement. I can approach with that. Or
Okay. Should be oh, you have amended without the clerk of this then? You consent to the filing of the amended information?
I would, Your Honor. Thank you.
All right, Mr. Harley, would you please stand and raise your right hand for me? Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Okay, you can have a seat, sir. Are you Marshall Arlen Harley? Anthony Harley?
Yes.
All right. And Mr. Harley, a guilty plea hearing is an important event that includes the waiver of constitutional rights that you have. So I want you to listen carefully. If you have any questions, ask me. If you need a minute to talk to your lawyer, you just say so. All right. And I have to advise you the maximum penalty that you could face for the charges you're pleading to in file 7141. It's count 1, possession of the controlled substance modafinil. It's a felony punishable by up to 2 years and or a $2,000 fine. And in file 7146, it's possession of count 2, possession of Suboxone. It's a felony again punishable by 2 years and or $2,000 fine. Because that offense was committed while you were on bond for the other one, those would be discretionary consecutive sentencing, such that the maximum by law that you could face would be up to 4 years in prison. Do you understand that, sir? Did you read and understand the rights listed on the advice of rights form?
Yes.
And you signed that form? Do you have any questions for me or Mr. Kukuski about any of those rights? Do you wish to give up those rights and enter this plea today? Sure.
Yeah.
Okay. Because we make a verbatim record, we have to get verbal responses. All right. And if I accept your plea, you give up any claim that it was caused by any promises that aren't put on the record, and you give up any claim that it was caused by threats. Do you understand that?
Yes.
And when you plead guilty, you lose the right to appeal. If you wanted to appeal, you have to seek permission by filing an application, but the types of issues that you could raise on an appeal after a plea are very limited. Do you understand that?
Yes.
All right, the plea agreement provides in exchange for your plea to those charges, the remaining counts and the habituals and enhancements will all be dismissed. Do you understand the terms of that plea agreement, sir?
Yes, I do.
Has anybody promised you anything else?
No.
Has anybody threatened you?
No.
Is it your own free choice to enter that plea?
Yes.
Knowing all this, how do you wish to plead to the charge in 7141, the possession of modafinil?
Guilty.
How do you wish to plead to the charge in 7146, the possession of Suboxone?
Guilty.
So, Mr. Harley, back in July of this year, were you in Sheboygan County?
Yes.
Were you in possession of the controlled substance modafinil?
Yes.
Did you have any authority to possess that substance? Do you have a prescription for it?
No.
Okay. All right, that's what I'm asking. Not like, did you steal it from somebody or what, you know? Yeah. Okay. And in September, were you in Sheboygan County again?
Yes.
And were you in possession of Suboxone?
Yes.
Did you have any prescription for that?
No.
And Mr. Kukuski, you satisfied with that factual basis?
I am, Your Honor.
Ms. Goodrich?
Yes.
Mr. Kukuski, are you aware of any other promises, threats, or inducements?
No, Your Honor.
Ms. Goodrich?
No, yeah.
And Mr. Kukuski, in your judgment, has the court fully complied with the requirements of MCR 6.302?
It has, Your Honor.
Ms. Goodrich?
Yes.
All right, Mr. Harley, I find that your plea in both files is knowingly, understandably, and voluntarily made, and if it is a sufficient basis in fact and in law to believe that you're guilty of those offenses. So I'll accept your plea. We can schedule sentencing for Tuesday, April 4.
April?
I'm sorry, August.
Thank you.
August 4th, sorry. I was seeing the number 8 instead of April. August 4th at 1:10 p.m.
Thank you, Your Honor.
And we'll continue status conference on the pending violations until that date and time. Ms. Goodrich, any objection to continuation of bond then?
No objection.
Okay, bond will be continued. And Mr. Harley, if you continue to not have any more violations, that'll be fine. I told the attorneys it'd be my intention to just dismiss those pending violations at the sentencing if we're clear between now and then, okay? If there's any more violations, we don't even have to, have any hearings really, because once you've entered a plea, you're no longer cloaked with the presumption of innocence. Bond is entirely within my discretion. So you don't want to have any more violations, okay?
Thank you, Your Honor.
Okay, you're all set, sir.
Thank you, Your
Oh,
Honor.
you have to cooperate with a pre-sentence report, so stop by the probation department before you leave and tell me you entered a plea, and they'll give you some information about scheduling. Okay?
Thank you, Your Honor.
I have this. Well, okay, let's do Pasino real quick, and then we'll. So I'll call People v. Victoria Pasino, file 25-7118FH. Counsel, you want to state your appearances, please?
William Key on behalf of Victoria Pasino.
All right, and this is the time and date set for sentencing on a charge of embezzlement over $1,000. It's a 5-year statutory maximum, 0 to 6 guideline range. There is a sentence agreement for a 6-month delay with a reduction to a high court misdemeanor at the end. And I did meet with counsel in chambers last week, I think, or last week or early this week. It was last week. To advise them that it would not be my intent to follow that sentence agreement, believing that for the conduct that was charged, if I'm sentencing for that conduct, it'd be my intention to impose likely 3 months of jail on top of any probation. And so based upon that, Mr. Keogh, have you had a chance to review with Ms. Pasino her options of either to go forward with that anticipated sentence or to withdraw her plea?
Your Honor, Ms. Pasino would withdraw her plea at this time, and we would, since we're kind of starting over again, we would just ask that this be set out for a docket call to give us some time. And I believe there's some restitution issues too that might need to be addressed as well. So we're looking for a date in the future so some things can be addressed in that regard.
Okay, so that is absolutely Ms. Pasino's right to withdraw the plea since there was no post-plea misconduct, so the plea is withdrawn. She's back to a pretrial posture, and we'll schedule this for a further docket call. Does July 7 give you enough time, and are you available that day, Mr. Keogh?
Is there a possibility it could be the week after that? Is it?
Not the week after, but 2 weeks after that, on July 21.
That's fine.
Is that okay, Mr. Juliet?
Yes.
Okay, we'll do July 21 at 1:20 in the afternoon. Let's see. 7, 8. All right, July 21st, 1:20 in the afternoon, and Zoom appearances will be authorized for that if that works, is what works out best for folks.
Very good. Thank you, Your Honor.
Okay, have a good day. All right, Mr. Pekowski, I see Miss Abbott zooming in. Please.
Good afternoon again, Your Honor. That's good. We have Ms. Abbott.
All right, and this is file 25-7088FH. Miss Abbott is appearing by Zoom video. Looks like she's joining the meeting. This was a case that was scheduled for sentencing last week, and we had I had indicated an intended sentence that did not comply with the terms of a sentence agreement. Therefore, Ms. Abbott withdrew her plea, which was her right. And then I was presented with a stipulation to remand the matter to the district court for misdemeanor plea taking. Spoke with counsel in chambers and advised them that I would not be remanding to the district court, although this court does have the authority to do so under People v. Kramer. Under 6.008, the court also does retain jurisdiction over misdemeanors for plea and sentencing in this court. And I've done both. It's sort of on a case-by-case basis. In this case, where I have announced an intended sentence, it'd be my intention to not remand to another court, because doing so could encourage not only this defendant, but any future defendants. That type of remand, the timing of that remand could encourage forum shopping or judge shopping. I just don't want to encourage that. So the case will remain with this court. And so, Mr. Kukeski, the status given that is that you desire another docket call, is that correct?
I would, Your Honor, and ask for another docket call at this time.
Any objection, Ms. Goodrich?
No objection.
Okay, so we'll set this for docket call. July 7 at 1:40. Would that work, Mr. Kukeski?
You said 1:40, Your Honor?
Yes.
Yeah, that should work for me.
Okay, so we'll continue this docket call to July 7th at 1:40 in the afternoon. And I'll allow Zoom appearances for that hearing if that's what works best for Ms. Abbott. All right, anything further on that file from the defense,
Not this time, Your Honor.
from the people?
Mayor.
Okay, Ms. Abbott, you're all set today.
Thank you, Your Honor.